recorded and live streamed on the county's YouTube page. Calling the roll, Ms. Turner.
Present.
Ms. Stevens. Ms. Stevens is absent. Ms. Simon.
Here.
Mr. Kelly.
Here.
Mr. Miller.
Here.
Mr. Sweeney. Mr. Sweeney's absent at the moment. Mr. Tuma.
Here.
Mr. Gallagher.
Here.
Mr. Schron. Ms. Conwell.
Present.
Council President Jones.
Here.
You have a quorum.
Thank you. Andrea, has anyone signed in for public comment?
No public comment has been submitted.
On miscellaneous business? We have a representative from the Department of HR who will facilitate our ethics training for our council members.
Good afternoon. I'm Dr. Alita Moonen. I'm the Director of OED for the Department of Human Resources, and I'm here to present your ethics training for 2023. Do you have any questions before I start?
What's the spelling of your last name?
M-O-O-N as in Norman, E-N as in Norman.
Thank you.
Well, without further ado, I will turn it over to Ricky.
Mormon?
Hi, my name is Alexa Beeler, and I am the Inspector General for Cuyahoga County. Welcome to your 2023 ethics training. As a county employee or elected official, you are required to abide by the Cuyahoga County Ethics Code. These rules set high standards and are in place to ensure that we are conducting ourselves in a way that promotes integrity, trust, accountability, and transparency in county government. The Ethics Code governs how we use county resources and instructs that they be used for county purposes only. County resources include everything the county owns or pays for, from paper clips to county-owned vehicles. This means you can't use county property or supplies for your personal or private use. County resources also include personnel and your time. The county is paying you for your county work with taxpayer dollars, so it is imperative that when you are at work, you are working. This means that personal matters and conversations should be handled during lunch or outside of work hours, and that your clock in and clock out times should accurately reflect your start and end times for the workday. When it comes to county time, a good way to keep yourself honest is to act like someone is watching, because even if your supervisor isn't, you can bet that your coworkers are. This is a frequent complaint our agency receives because county employees who are doing the right thing don't like to see county employees who are not.
There are a few exceptions where the use of county resources for private or personal purposes will not be an ethics violation. If the use is authorized by law or county policy, or if the county resource was provided to you as part of your official compensation, then it's okay. Also okay is de minimis use of county resources. When you look at the dictionary definition of de minimis, you'll find things like too small to be meaningful or taken into consideration, immaterial, and so minor as to merit disregard. What that means in practice is that a 5-minute personal call on county time or using a paperclip or staple for personal use would not be a violation of the ethics code.
However, we caution you to be careful. Even though the Ethics Code allows a de minimis use of county resources, you don't want to find yourself in a situation where our agency is looking into your use of a county resource to determine whether or not it is de minimis. It is always safest to err on the side of caution. Also, just because the use of a county resource is not an ethics violation does not mean that you are always in the clear, because you also have to comply with other county policies. Your supervisor may have stricter standards, and it is important to note that even a brief digression from your work duties to browse the internet may be a violation of the county's internet use policy. And there are some things that you should never do with county resources, even if de minimis, such as using any amount of time or tangible resources for non-county business or political activity.
The county has approximately 5,000 employees, so it's not surprising that we have employees who are related to other employees. The Ethics Code defines relative broadly and includes your spouse, domestic partner, parent, grandparent, step-parent, sibling, step-sibling, sibling spouse, your child, your grandchild, your stepchildren, uncles, aunts, nephews, nieces, first cousins, and household members, and anyone that has any of those relationships to your spouse or domestic partner.
Having relatives work for the county is not by itself an ethics violation. However, you cannot have a relative in your chain of command. No employee may supervise a relative or participate in any way in a decision to appoint, hire, promote, discipline, or discharge a relative for any position of the county. This means that even being a part of this discussion is strictly prohibited.
If you have a relative that works for the county, you must disclose that relationship to the Agency of Inspector General by completing a nepotism statement, which can be found on our website.
Your position with the county should only be used to benefit the county and should never be used to secure a financial or material benefit or a promise of a financial or material benefit for yourself, a relative, a business associate, or a private organization that has any relationship to you, your spouse, or a member of your household. If you are ever faced with a situation where your work with the county could secure a benefit to you or a person or organization related to you, you must not act, and you may need to take the additional step of disclosing the issue, which we'll talk about in the next slide. And as always, if you are ever unsure, please come to us for guidance before you act.
Supervisors should not have their subordinate employees do personal tasks for them. You cannot require or coerce a subordinate employee to perform any task unreasonable outside the scope of his or her county employment that does not further a county interest. This includes things like picking up your dry cleaning or lunch and performing clerical or other work on your behalf, on behalf of your family, your business, personal or political interests. Supervisors may, however, ask their subordinate employees to perform non-county tasks on personal time, as long as they offer just compensation for the performance of those tasks. Be mindful that subordinate employees typically aim to please their supervisors, so they may not feel as though they can say no to such a request and might feel pressured to say yes, even if that wasn't the intent. For this reason, excessive requests by a supervisor to perform tasks unreasonably outside the scope of a subordinate employee's county employment may constitute a violation of this section, even if just compensation is offered.
The Ethics Code also breaks out a few specific examples that are considered to be a misuse of official position. For instance, you cannot knowingly misrepresent your personal opinion to be the official position of the county, nor can you have the county pay for you to attend a conference and then fail to attend without obtaining approval or refunding the cost to the county. Also, as public employees, you are bound by Ohio's Sunshine Laws, which means you have an obligation to make public records available for inspection or copying and cannot destroy, manipulate, or suppress public records. Confidential information, on the other hand, must be kept confidential forever. You are never allowed to disclose any confidential information you obtained during your county service, both while you are serving the county and forever after. You are additionally prohibited from accessing any information that's not related to what you're doing for your job, and you absolutely cannot use any information you learn to benefit yourself.
As public servants, we have a responsibility to make public decisions objectively with the county's best interest in mind and not based on our own interests. Conflict of interest occurs when you have an interest on both sides of a matter. You could have a conflict of interest if your personal interests or the interests of relatives or business associates could compromise the decisions you make in your county position. For example, let's say the county decides it wants to purchase new chairs, and you're one of the county employees in charge of selecting the chairs. Let's also pretend that your brother owns a local chair company and submits a bid. You would have a conflict of interest because doing what's in the county's best interest could be impaired by the interest that one of your relatives has in the outcome.
Having a conflict of interest is not illegal, and in fact, they're actually quite normal because public servants have families and friends and may have businesses and other connections to the community. It is how we respond to the conflict of interest that matters. Anytime a matter involving the exercise of discretion comes before you that could result in a direct financial or material benefit to you, your relative, your business associate, or any private organization in which you have an interest, you are required to disclose and recuse. The disclosure must occur as soon as you first learn of the potential conflict of interest, and it must be made either to the public in an open meeting or in writing to the Agency of Inspector General. You must then recuse yourself from the matter by fully and completely abstaining from making decisions about or influencing how the matter is resolved. This includes refraining from not only voting, but also from discussing, reviewing, recommending, inspecting, investigating, or taking any other action on the matter, or participating in any way whatsoever.
Additionally, you cannot be compensated by a non-county entity to perform services on any matter that is before any county agency or department, even if it's not your own. This means that you cannot be paid by an outside person or organization to represent them or perform services on any matter before the county, even if the matter is with a division of the county other than yours, and even if you will not personally appear before the agency. For example, let's say an outside client wants you to prepare drawings that will be submitted to the Department of Public Works. You will never appear before the county, and let's say you work in the fiscal office. You would not be allowed to do this because you cannot receive compensation from a client to do work on a county matter, even if your name or face aren't attached to the work, and even if it's not before your department or agency.
As with most of ethics law, conflicts of interest issues are extremely complex and fact-specific, so please reach out to our agency when you first become aware of a potential issue so we can help guide you in making a decision that won't have negative repercussions in the future.
As a general rule, you cannot do business with your public employer. This means you can't sell goods or services to the county, and this is true whether there's a written contract or not. You can have no part in authorizing a contract that could benefit you, your family, or your business associates. If the county is spending money on something with which you have a connection, please reach out to the Agency of Inspector General to make sure you're not breaking the law. For instance, if there's a county grant to a nonprofit you're involved with, or a contract with your spouse's employer, or if the county wants to buy something from a business you co-own, there could be an issue. The benefit to you or a person or organization connected to you doesn't have to be financial for it to be a problem. So if you serve as an unpaid board member for a nonprofit that receives operating funding from the county, it could be just as big a problem for you as if you directly sold the county goods.
There are very narrow exceptions to this general rule. However, they require such a detailed level of analysis, and there is so much at stake that we won't even address them today other than to say, come to us so we can help guide you through this type of issue. It is important to note that this is a criminal statute and a violation could result in a felony. So anytime you or someone close to you could stand to profit from a contract with the county, please reach out to us.
There are very strict rules on whether and when someone in public service may accept a gift. A gift can be anything of value. Common gifts that those in public service may encounter are meals, travel, discounts, conference fees, and entertainment, as well as gifts around birthdays and holidays. In deciding whether you may keep the gift, it is important to look at who wants to give you the gift. If the giver of the gift is a person or entity who does business with the county, is seeking to do business with the county, or is regulated by or interested in matters before the county, then you cannot accept or solicit a gift from that person if the gift is significant. There's no hard and fast rule about what is considered significant or what dollar amount is deemed significant. So you should always err on the side of caution and reach out to us for guidance.
Even if the gift is not significant, you are never allowed to accept something that is intended to influence your official duties. The County Ethics Code doesn't allow you to accept any gift from someone if a decision you have to make could affect their interest, even if the gift would usually be something that is considered insignificant and allowable. For instance, if you are reviewing proposals for an upcoming county contract and the president of a company who submitted a proposal wants to buy you a coffee, don't take her up on it. Also, gifts should never go up the chain of command. It is almost always true that subordinate employees should never buy any gift, regardless of its significance, for their boss or anyone above them in the reporting structure.
As with most everything, there are exceptions which may apply. For instance, reasonable, customary gifts for special occasions are usually okay. Special occasions include things like marriage, illness, retirement, and the birth of a new baby. But they do not include birthdays, and they certainly do not include Boss's Day. It's usually okay to accept meals and refreshment of an ordinary character if you're speaking at a professional event or if you're attending a fundraiser or community event.
There are many factors that must be taken into consideration in determining whether a gift is appropriate, such as who is giving the gift, why they are giving the gift, how many public employees they are giving the gift to, and how significant the gift is. This area is very fact-specific, so please come to us before accepting any gifts so we can help you act within the rules.
You cannot accept any rewards or gifts for the performance of your county duties from any source other than the county. Your county salary and county benefits are the only compensation you should receive for your county work. You can never accept a gift as a thank you for performing your public service, whether the gift is of significant value or not. The County Ethics Code presumes that a gift is intended as a reward for official action when the gift is from a private person or organization that has obtained county action that involved your participation within the preceding year.
All thank you gifts are prohibited, whether it's to compensate you for a specific action or decision, or just for the general performance of your job duties. So you cannot accept a gift from a developer whose loan you just helped finalize, nor can you accept a gift from a member of the public as a thank you for your public service.
Whether you are allowed to engage in certain types of political activity often comes down to whether you are unclassified or classified. In general, unclassified employees are not restricted from engaging in any type of political activity, as long as it's on their own time and they don't use county resources or misuse their county position. However, classified employees have much stricter rules, and while they can still participate in activities such as registering, voting, contributing, and expressing opinions, they cannot participate in any partisan political activity. So for instance, classified employees cannot campaign for a candidate for partisan elective office, solicit money for any political party or partisan candidate, or participate in any activity that is geared towards party success.
Whether you are unclassified or classified, you are never allowed to donate to or solicit donations for the re-election campaign of your own currently elected employer or confirming authority, just as those elected officials are prohibited from soliciting or accepting campaign contributions from you. You may, however, make voluntary campaign contributions to other political parties or candidates for any other public office. For example, if you work in an executive agency and the current county executive is running for re-election against an opponent, you would be allowed to donate to the opponent's campaign, but not the current county executive's campaign.
Up until now, we have talked about all the things the County Ethics Code prohibits you from doing, but these next few topics address the actions the Ethics Code requires you to take. The first is with regard to secondary employment. If you have any outside employment that the IRS wants to know about, then we want to know about it too. You must file a secondary employment disclosure form that can be found on our website. And once received, we will determine whether your outside position and your county position are compatible, and whether there are any conflicts of interest that would prohibit you from holding both.
Disclosure is also required if you have a fiduciary interest with an entity and that entity receives funding from the county. This is required even if the position you hold is uncompensated. So for instance, if you are on the board of a nonprofit and that nonprofit receives any amount of money from the county, you must disclose that to our agency even if you are not paid for your services.
In either case, you are required to disclose within 30 days of accepting your outside position, but we encourage you to disclose as soon as possible so we can help you avoid any potential problems.
While you are in your county position and for 1 year after you leave, you cannot do any work for an outside person or entity if that work is related to a matter in which you personally participated in your county position. So if you worked on something for the county, you cannot then go and work on that same matter for another person or organization. For instance, if the county contracts with a vendor for one of its various programs, and your job with the county is to do work involving that program, you cannot go work for that vendor on the same program for 1 year after your service with the county ends.
You are required to disclose to our agency anytime you are seeking employment with an entity that is doing business with the county, seeking to do business with the county, or is in any way interested in matters before the county or regulated by it. This disclosure is required when you take any steps to seek employment with such an entity, including responding to a job advertisement or sending a resume. It's not just limited to when you receive a job offer. The Agency of Inspector General will help guide you to make sure that you don't unintentionally violate any ethics laws, both while you are still employed by the county and with any future employer.
A whistleblower is someone who reports wrongdoing, and that report is referred to as a whistleblower complaint. The County Ethics Code requires you to report known ethics violations of Cuyahoga County employees, elected officials, and board members. There is no guesswork involved. If you know of an ethics violation, you must make a whistleblower complaint in order to be in compliance with the Ethics Code. if you see any activity that you think might be contrary to law or regulation or any evidence of fraud, waste, corruption, or abuse, it is easy to report and you will be protected from retaliation. And this is true even if you were wrong, as long as the reporting was done in good faith. If you make a whistleblower complaint and then experience retaliation, you may file a complaint with the Personnel Review Commission, who will then determine if retaliation occurred and issue an appropriate remedy.
It's easy to make a whistleblower complaint, and you may do so in a number of ways. You can choose to report in writing or verbally, and if you don't feel comfortable disclosing your name, you may report anonymously. You can choose to report to our agency, one of your supervisors, or the Department of Human Resources.
To those employees who are supervisors or are in HR, you have additional responsibilities. You must never retaliate against a whistleblower, and if a whistleblower comes to you with an ethics violation, you need to ensure that it gets into the right hands. This means that if the whistleblower complaint is verbal, you must prepare a written record. Supervisors, you must notify either our agency or HR within 5 days of any whistleblower complaint you receive. And to those employees in HR, any whistleblower complaint you receive must be given to our agency within 5 days.
There's truly no wrong way to contact our agency. You can call, write, or visit us in person. Whether you have a question about taking a certain action without violating the ethics code, or if you have information about a violation, we want to hear from you. And we want you to reach out in a way that works best for you.
The two most important things to take away from today's training are to ask before you act, and if you see something, say something. And remember, there is no wrong way to do either. Thank you for your time today and for all that you do for the county.
Thank you for your attention. Are there any questions? Thank you very much.
Thank you. All right. If nothing else holds our attention, yes, Councilman.
Thank you. Just while you're recognized.
Oh,
I
Councilman
was going
Martin
to
Sweeney is
state that
here.
after he's
Yes.
finished. Thank you for the record.
All right, if nothing else holds our attention, this meeting is now adjourned. We will reconvene in about 10 minutes for our council meeting.